Good evening, everybody. Hearty welcome on the second day of webinar, Current Issues in IPR and Anatomy of Patents. Friends, at the outset, I must pay my gratitude to all speakers and participants. I must mention here that because of enthusiastic efforts of Mr. Pratik and Professor Bunty sir, the college with IEEE Bombay section can organize this today webinar. Friends, expressing few words about the college and its activities. 93 years old, Akola Education Society established Akola Law College in the year 2005 with a 5-year law degree course and then post-graduation in 5 groups and added 3-year degree course. And happy to share very soon the college is going to add one more feather in its cap in the form of Legal Research Center. The college organized number of conferences, guest lectures, workshops, and this become possible because of the Honorable Professor Panditat Mandavani, President of Akola Education Society, and a person who is serving the society with revolutionary vision of education, and Dr. S.C. Bhandari, founder principal of Akola Law College. Friends, the legal scenario in India has undergone tremendous changes during previous couple of decades. The advent of information technology in all spheres of life has transformed the way of human working. In a recent scenario of COVID 19, the whole world is facing many problems. However, in the backdrop of Startup India and now Atmanirbhar India, the importance of intellectual property enhanced. This is the first step of the college to connect digitally in the intellectual discourse with the world at large. Yesterday, we had sessions on a brief introduction of IPR by Advocate Vidyadhar Kulkarni, where he talked about what are the patents, copyrights, trademarks, geographical indication, and industrial design. This helps us to understand the basic of intellectual property rights. In the second session, saw where India stands in a present scenario. Advocate Mario Sequeira briefly described the status of IPR in India versus top 10 countries, and he also answered questions regarding what we can do to improve the present status. Today, towards the last session, Advocate Ashish Sonone put light on IPR and composite IP strategy. His session included various case studies like Virgin, Apple, Samsung, Sunfight. His explanation of economics of IP was well received by all. The explanation he gave for patentability finds a good place of most useful knowledge one must have when talking about IPR. His oral session was enlightening towards practicality. Participants, today again we have three more intellectuals among us. Honorable Dr. Ushashi ma'am, Professor Kiran sir and Dr. Pankaj sir. I welcome you all on behalf of Akola Law College and Bombay section of IEEE. In the first session, we will talking about copyrights trademark, where Dr. Guha ma'am will enlighten us regarding copyrights trademark. As Advocate Mario correctly said, in this era of virtual reality, copyrights play an important role. And Advocate Ashish explained importance of trademark with the example of Virgin. Hence, this session has its own importance. As correctly described by Advocate Mario, one of the reasons India is lacking behind is improper drafting by applicants. Hence, to put some light on drafting and documentation, we have Professor Kiran Talela sir. The third session is by Dr. Pankaj Borkar, who will guide us on a patent filing process. The last session, as yesterday, will cover maximum queries of participants. Dear participants, I wish to mention here that Professor Kiran sir, Associate Professor, Chairman Student Activities Committee, and Executive Member of IEEE Bombay section, is so open-handed to give consent to this collaboration. Kiran sir, I am confident that we can do many more activities jointly in this field. Akolala College is really a small entity with a determined spirits fired by unquenchable faith in the mission. We are marching forward by transform the course of academic history positively. Once again, thank you and handing over the session to Advocate Ujjwal Deshpande to move forward. Over to Advocate Ujjwal. Thank you. Thank you so much.
Good afternoon, all the viewers. Good afternoon to all the viewers. Today is the second day of this webinar series on the intellectual properties. Yesterday, our guest speaker had enlightened us on the three topics, that is, brief overview of IPR, a comparative study of status of IPR in India vis-a-vis a top 10 developed countries, and IPR and composite IP strategy. Today also, we are going to enjoy the same intellectual feast, and for that, our esteemed guests and speakers are firstly Dr. Ushashi Guha ma'am, Professor Pankaj Tarele, and Dr. Pankaj Borkar. This first session would be conducted by Dr. Ushashi Guha ma'am, and our first speaker for today's session, Dr. Ushashi Guha, would enlighten us on the various niceties and nuances related to trademark and copyright. Dr. Ushashi Guha has done PhD in Law and Education, MSc in Mathematics, LLB, LLM, MBA, MAd, and post-graduation in Cyber Law. She has served 26 years as principal, approved of Kinkar College of Education, Selu, Wardha, and presently also she is faculty for the LLB and LLM in Rashtrasanta Tukdoji Maharaj Nagpur University. She is an approved guide of PhD in Nagpur University. Madam has more than 15 years of experience in the field of intellectual property. Madam has delivered many guest lectures in and around India and undertook various projects and fellowship in USA, UK, Israel, Egypt, Sri Lanka, Bangkok, and Nepal. Madam has received many national and international awards for her research papers at national and international level. She is the recipient of MSME Award, and recently she is awarded the RGNIIPM Award by the Government of India. Madam was also amongst few who were selected for the Global Peace Award 2019 by the World Commission of Protected Areas and CCEAM International Award of Fellowship 2016. Ma'am is the lead associate assessor of ISO 9001 and 2008 and an honorable IPR attorney to MOIL Government of India, an advisor of IPR cell in Gondwana University, Karad University, Datta Mege Institute of Medical Science. She is the panel of MSME incubation cell as well. So now, without taking much of your time, I would request Ushoshi ma'am to take charge of this session. And over to you, ma'am, please.
Good afternoon, everybody. Am I audible? Am I audible? Is it okay? I start with my session that is on copyright and trademark. To begin with copyright, before I start with copyright, I just want to show you a slide which is concerning all the intellectual properties that are embedded in one particular device, instrument, or a thing that we are ever using. Please look at the slide. Please look at the slide. It is visible. Yeah, yeah. Now, see the first example. We can see a car. Okay, this is an Audi car. Now, let's see how many IPs there are. Of course, all of us know. But then, once more, I would wish to say that this Audi, with those four size circles, one within the other, you can have a trademark for this. The Audi name and the logo. You can trademark it. It is one of the IPs. The next one, just see, this is copyright, changing the narrative. I mean, a lady, a model, she's showing a victory sign and she is narrating something. There can be copyright of the narrative. That is also an IP because IP covers your copyright, trademark, patent. I'll go one by one. So for this car, we have first seen that what part of it would have trademark. Now we are seeing that what part of it will have copyright. Otherwise, we think that a car has only patent, but it can have copyright. The copyright lies? The narrative. And the narrative is so lucid that it attracts, it talks about the car, the narration, the model, the figure, the photo that attracts the model of the car. Next, you just see the outer part of the car. The outer part of the car, it has a particular look. It has a particular kind of configuration that is known as design under IP. So outside part is the design, and inside whatever is the machinery, whatever is the technology, that goes under patent of IP. So under one umbrella of IP, one particular device, that is a car which we see running on the, which we own, which we feel like buying, that can have all these four kinds of IP, and it has to have. So any device, anything that has outer look and inside instrument. Outer look is design and inside technology is patent. Whatever has been said about the car, which has been written in a literary form or in picture form or in the musical form, that has copyright. And then the logo, the name, the brand name, it goes as trademark. Now I am coming to next slide. What is copyright, friends? Copyright, it is an exclusive legal right. Now, who gets the legal right? In case a lecturer has made his own lecture, that if he has created the lecture, it is an intellectual work, and the lecturer has a legal right over whatever he has created, and that will be his exclusive right. And why the word legal? Because in case of any kind of infringement, the law is attracted. It can go to the court of law. Second point I want to just emphasize here is copyright owner has rights too. It is the owner, that means one who has produced. He only can reproduce it, he only can translate, adapt, perform, distribute, display the work. So, all the rights are owned by the owner or the creator. Here, the third part. My friends, I draw your attention to this third part because always it attracts controversy. But then, please mark the wordings. Registration is not mandatory. Now I'll come where it is mandatory. Here, this not word. Registration is not mandatory. That's how the law goes. Okay, since copyright comes into existence as soon as the intellectual work is created. That means if I start writing a poetry, I write the poetry, I am the creator of the poetry, immediately my copyright starts there. But, and it is not mandatory, my copyright starts. But then that is open to the public. If anybody if anybody wants to reuse it and puts it into his own name, I will be hurt. In that case, I will ask him, this has been created by me. But the person in front, he may ask me, have you registered it in my name? The moment I said I haven't registered, he can use it. So once I have created, my copyright starts. But once I register it, I prohibit others for using it. That means once I register it, it becomes my legal right. But I create, copyright exists means my legal right to it does not exist. Is it okay? Am I okay? I would attract some questions later on, of course. Now I'm coming to aspects of copyrightable work. Aspects means what are the mandatory requirements for a work to be copyrighted. It should be original. That means there should be creativity in it. Here, originality sometimes or always original and creative. That is, creativity should be there. The skill should be displayed. The labor should be there. There should be novelty. Applicability of it is also there. Ideas cannot be copyrighted. That is why look at the first small figure. Idea is there. Out of the box, idea may be there, but applicability is not there, and you have not put it on a medium. That means you have not written it out, or it is not on any CD, or it has not been displayed. Only ideas out of the box or inside the box, they cannot be copyrighted. So the copyrightable work, it is not like taking an axe and just hammering it out. It is not the ideas into some kind of machine, but then they are to be applied, they are to be shown, and then they are to be of use. Now, ownership. Here, I would ask you, I'll give you 1 minute to see the whatever photographs or whatever is displayed. Okay, shall I go ahead? See, yeah, an office. The owner is there. Owner has appointed his employee. Now they have a kind of agreement in the middle. The agreement says that, or see, there is a contract, there is an agreement. So there is an agreement. The owner is telling the employee that you agree to my terms and I'll give you salary or some other kind of goodwill. In lieu, you are going to work. So the copyright will exist with the owner, not the employee, unless otherwise employee in so many words comes to an agreement saying this is my invention and I will have a percentage of it, or I will be a co-owner. Unless otherwise the employee tells it or prepares an agreement legally with the owner, the complete copyright goes to the employer or the owner. My friends, I repeat that copyright is that of the owner. Second figure, the owner, and the agreement is with some valuable consideration. In that case, with a percentage, they can have a co-ownership. Who? The person who is working here, an artist, he is working here. The owner, she is a cinematographer, he is a cinematographer. Another, she is a cameraman, a photographer. A photographer is under an agreement with the owner. There are two kinds of agreements. If the photographer says that for a valuable consideration, you are the owner of consideration, means you are the tenant. Otherwise, if these people, they have a kind of agreement saying on a percentage, I am a co-owner, then the owner has to give money. In short, if in an office an employer has appointed an employee is working and he has been given salary, whatever the employee, whatever this fellow finds produces, that becomes property of the owner. It always is happening with the press, with the newspaper, with other kinds of magazines. So ownership, make an agreement. See here, it's very important. Make an agreement with the employee regarding copyright matters. Always, always. See, there are so many types of scholarships We go to national institutes and scholarships are there. But in the beginning, we get the scholarship, but there is an agreement. We don't read the agreement fully. We may be reading, but we miss the legal part of it. And the whole thing goes to the institute. The ownership is that of the institute. Hence, it's very important that make an agreement with the employee regarding copyright matters, especially where artistic work is there, musical work is there, and write-ups are there, written material is there. Am I okay? I'll go ahead. What are the works that are covered under copyright? I believe all of us know about it, but still, I have displayed here. It is literary. There is, I'm coming to literary. First work is literary. It is a category. Literary category of copyright. It includes software, books, essays, compilations, computer programs, websites, all this. Here, you just see periodic table of elements. It has a copyright. You see the research, it has a copyright. And then likewise all this. Friends, at this junction, allow me to mention one thing. Those of us who are in academics, everybody is in academics first and then they go into profession. Okay, even in profession also the academic part remains with them. We do what? We develop, we produce, even in research, while we write essays, research papers, we make haste in sending the research papers to the particular publisher or research authorities. We forget to copyright. My humble suggestion to all of you, my very humble suggestion, that as soon as some research material is developed, it has been written out, please copyright it. All the colleges now, they have IQAC or an IPR cell. Go to IPR cell, it doesn't cost too much. Just shell out a little money, whatever fees and whatever other professional fees, just pay that, get a copyright, and then only send it to other, that is secondary, whatever places you want to send. Because we have a big hurry in sending the research paper. Don't be in the hurry. Give at least one day in between when you can get it copyright. Your college, you can go to your college, you can go to your office. Otherwise, people like us and so many advocates are here. We can always run down to your help, such that get it copyrighted, such that whatever you have created, that goes under your name, but not under anyone else's name. Okay, let me go over. Work covered under copyright. First we did literary. This is the second part, that is artistic. In artistic work, we have drawing, painting, logo, map, chart, plan, photograph, work of architecture also. This is a very huge field, that how the work of architecture is covered, or it can be registered, covered. I draw your attention to the third figure where you can see a building plan. A building plan, it is a creation of the architect. The plan covers all the measurements. The plan covers the interiors. The plan covers how best the arrangement of the thing should be. This plan, it cannot be just open to the public. This plan, it has to be copyrighted. And it is a complete beautiful area. I can go on talking about it. And my humble suggestion to the architecture faculty people or the civil engineers, please try to hear from somewhere how architectural plans, they can, how the work of architecture, they can be covered under copyrights. I once again repeat that any drawing, pencil, see, even right from the school children to those who draw the rangoli, any creation which has novelty, which is created on a medium, that can be copyrighted. Any painting, beautiful painting, see the scenery and beautiful paintings, they are displayed in so many places with themes. The painting should be copyrighted. Then logos, as I showed you about Audi, etc. Logos should be copyrighted along with trademark. This is again one more field, that how the logos, they contain the trademark and copyright both. Sometimes logos, they just go as a logo, but whatever punchline or other things are written, they are exposed to the public domain and they are uncovered by copyright. Then map, chart, plan, photograph. Here, look at the beautiful sculpture photograph. They are all the they are all under the cover of copyright, and it should be registered. Unless it is registered, it is prone to the theft and prone to be copied by others. Now I am coming to the third, sounds recording, cinematograph, musical work. They all carry copyrights fetch which fetch huge value. Friends, do we not remember when we hear from some radio station that this is a song like Vivid Bharti or some other radio station, that the sound recording has been done by HMV, it belongs to that cinema, and music has been sung by this, and who has written the notations of the music. Just see, a music otherwise, somebody is performing a music that doesn't carry copyright, but the notations, that's why here the display shows in the musical work that the notations are to be in a tangible form. It has to be written, and those notations along with the song, this has to be copyrighted. Then only it goes under the credit of the creator, because creator first prepares the notations and then it is performed. That is why only performance doesn't contain any copyright, but notations with the performance, it carries the copyright. Now, can I go to this cyberspace copyright infringement? Can you just go to see there is this cyber software piracy? On digital work also there is piracy. In linking, deep linking also, if there is some kind of piracy, these are all the areas in which the copyright has been infringed. And the cyber law is very clear. Cyber law. On the cyberspace, any infringement, we have IT Act in India. Otherwise, WIPO has so many infringement related, because all the countries, they have on cyberspace, the space word itself says that it is not country specific. It can go into other countries also. Most of the countries have their own IT Act. And the IT Act, it talks about what is infringed, how it is infringed, and what is the penalty. And according to that, the infringement penalties are assigned. So now, on cyberspace, yes, many are falling prey to the infringements or the cyberspace attacks. But then, once infringement is caught hold of, then it is very quickly, it is detected, and at the same time penal action starts. One thing, my friends, I being a cyber lawyer also, let me tell you, the moment you find that some kind of copyright is under attack, you immediately come to a lawyer who can start working with the legal recourse. Okay, that is the whole thing about infringement. I have not talked about how the things are infringed in the banking, how infringement is happening in other areas, how infringements are happening in your credit cards, debit cards. I was under attack with Amazon, क्या था वो? Amazon Prime. Immediately I had to block it. And then remedies against copyright, there are civil remedies also, there are criminal remedies also. In criminal remedies, the penalty I've already mentioned, it is between 50,000 to 2 lakh. And in civil remedies, there is injunction. That means you are the one who has surpassed your or who has infringed your copyright. The person who has infringed your copyright, he has to withdraw or sometimes pay the fine also as the court assigned. But then there are legal remedies. I should have written legal remedies, criminal also, civil remedies against copyright infringement. This is a small, just for your, just because we have been seeing all this. Now, these are the Bollywood movies from copied from Hollywood movies, and the cases are going on. It includes even Chakde. Please go to that. Please go to this. Kindly see. Please see. Few of the famous movies, they are copied from Hollywood movies, and they are under the court proceedings. Now, court proceedings, many a times, they are settled. The court itself says that civil remedies are given, they are settled, and there are very few against which it has gone up to the High Court, Supreme Court, and higher courts. So, movies are copied, music is copied, and the moment I talk about copied, we must think about copyrighting our own created work. It doesn't take, even today also, it doesn't take much time, it doesn't take much money. So the creator should be very, very cautious to protect his own creation under his own ownership. Unless it is registered, someone else would pass it off in his own name. Now, before I come to procedure for registration, okay, I'll go very quickly about procedure, and then I would attract some questions from those who are in this webinar. Kindly give me questions after going through this slide. Please go through this slide. Applicant or author can file the application for registration of copyright. There should be one application for one work. Application can be made through physical or e-filing. E-filing facility is very quick and very easy. Each application in Form 14 should be accompanied by fees. Fee ranges, see, it is as low as 500 plus 40 and 40,000. Never say कि 500 रुपए में copyright होता. It ranges. What is your work? How heavy is your work? What form of work? All these things they are consulted. Then the fee can either be in the form of demand draft or postal order, etc., etc. I think all of us know about it, or through e-payment. The e-payment, the gateways are working wonderfully. So sitting in a place during the days of Corona, I'm getting so many work, because people, teachers, the medical people, and the artists, they are working at home and they are copywriting. So my friends, don't leave it without registration. Please do copyright, cover it under your name, have the ownership, and then later on you can ask others to use and reuse.